This is Professor Russell James coming to you from Texas Tech University. Welcome to today's lecture from Visual Plan Giving, an introduction to the law and taxation of charitable gift planning. Welcome to Charitable Gifts of Homes and Farms with Retained Life Estates, Part 5, Rules After the Gift is Made. This is Professor Russell James. The remainder interest gift allows the donor to retain the use of the property for the rest of his or her life. Actually, it is much more flexible than this, allowing for any period of years or the life or lives of any person or group of people, but such alternatives are rarely used. What happens if the donor no longer wishes to use the property? Perhaps the property is a personal residence and the donor decides to move away to a warmer climate or to a nursing home. Or perhaps the property is farmland and the donor becomes unable or uninterested in continuing to farm. Whatever the circumstances, either anticipated or unanticipated, the donor still has a variety of options available when he or she no longer wishes to personally use the property. One easy solution is for the donor to simply rent out the property and take the income. If moving to a distant state, the donor will likely hire a property manager to manage the leasing and maintenance of a residence. It is also possible to sell the life estate to an investor who would then rent out the property, although such transactions are rare. If the charity owning the remainder interest is cooperative, both the life estate and the remainder interest can be combined and the property can be sold with normal fee simple ownership. The division of proceeds between the charity and the donor must give the charity at least as much of a share of the proceeds as the IRS tables indicate the remainder interest is worth based upon the donor's age at the time of the sale. Most charities holding a remainder interest would be more than happy to agree to a sale and division of the proceeds. Although less common, a charity could agree to issue a charitable gift annuity, discussed in a separate series of lectures, in exchange for the donor gifting the life estate. The gift of the life estate would allow the charity to combine the life estate and the remainder interest and sell the property as a whole. Proceeds from this sale could then fund the gift annuity payments. Of course, the same could be accomplished by a joint sale where the donor used the proceeds from his or her share of the sale to then purchase a gift annuity. However, this transaction would require the donor to immediately recognize any capital gain upon the sale of the property, whereas the gift annuity transaction would postpone such taxation. Conceptually, the donor could even place her life estate interest into a charitable remainder trust prior to a joint sale in order to avoid capital gains taxes. However, this is rarely done because the transaction amounts are not normally large enough to warrant the use of the more complex transaction, and because the donor could not live in or use the property after it was transferred to the charitable remainder trust. Finally, of course, if the donor were financially capable and charitably inclined, the donor could give his or her life estate to a charity. The gift could be to a charity holding the remainder interest or to any other charity. This is a deductible gift, even though it is the transfer of only a partial interest in property, because the donor would be retaining no interest in the gifted property. One concern a charity may have about such transactions is whether or not the donor would choose to maintain the property. Of course, a charity could take the attitude that some gift is better than no gift and not concern itself about the risk of the property deteriorating or burning in the meantime. But suppose the charity wished to maintain the value of its remainder interest. What are its options? Although unfamiliar to most people, the life estate/remainder interest property division is a very old form of property ownership. Because of its long history, the rules for such ownership are well established in court cases referred to as common law. These rules require that the owner of the life estate, referred to as the life tenant, must pay for maintenance, insurance, and taxes, also known as MIT, on the property. Should a life tenant fail to pay for these, the holder of the remainder interest has the right to force payment through court action. Some charities like to avoid such legal actions if at all possible. This is one reason why it is common for charities soliciting remainder interest gifts to require a written MIT contract. that is, maintenance, insurance, and taxes. By requiring such an agreement, the charity can ensure that the donor understands his or her obligations. Even if the agreement places no more obligations on the donor than those provided for in common law, it can help to resolve conflicts by serving as a reference point for future conversations. This can be especially important in circumstances where the original donor is no longer managing the property, due perhaps to incapacity, or where the donor was not the life tenant. The typical scenario where a donor is the life tenant usually creates few problems because the donor wishes to benefit the charity. However, if the life tenant is hostile to the charity, problems are more likely to arise. For example, a donor could direct in his will that a personal residence could be used by his sister for life, with the remainder interest going to the donor's favorite charity. In this case, the life tenant may have no interest in or connection with the charity. When there is no relationship and the life tenant fails to maintain, insure, or pay taxes on the property, the charity can take one of several strategies. Using a standard approach, the charity can simply enforce its legal rights through court action. Although this path is available, some charities might decide not to enforce their legal rights because of the risk of bad press. In this case, it would probably be best for the charity to sell its rights to another investor, who would likely be far less concerned about public relations. If the charity is unwilling to enforce its rights or sell its rights to another investor, then the charity must be content with the land or salvage value of the property remaining at the life tenant's death. Note that, depending on state law, it may not be wise for a charity to intervene by paying taxes on the property. Unpaid taxes will ultimately result in the forced sale of the property, the proceeds of which will be subject to distribution, in part to the charity as holder of the remainder interest. The life tenant has the obligation, either under common law or under a written MIT contract, to maintain, insure, and pay taxes on the property. But what about a life tenant who wishes to make improvements to the residence? Such improvements are certainly allowed by common law, although they must truly be improvements and not diminish the value of the property. What are the tax consequences of making improvements to the property in which the remainder interest is owned by a charity? The indication from IRS private letter rulings is that improvements made to property where the remainder interest is owned by a charity constitute additional charitable gifts. Improvements to a residence, such as the addition of a bedroom, increase the value of the property. The deduction would be based upon the increase in the value of the property multiplied by the percentage attributable to the remainder interest owned by the charity. This would be the same calculation process used previously, but updated for the donor/life tenant's current age. Thus, a donor who has given a remainder interest in his home to his favorite charity can generate additional tax deductions for any improvements made to his home, so long as the charity owns the remainder interest at the time of the improvement. The charitable gift of a remainder interest in a home or farmland with a retained life estate is a relatively simple transaction that begins to demonstrate the power of sophisticated planning. Donors are able to take an immediate tax deduction without making any changes to the way they will use the property for the rest of their lives. Donors can use the value of this deduction to spend on themselves, invest in income-producing assets, or even purchase tax-free life insurance for heirs through an ILIT. Although infrequently used, for the right donor and the right charity, gifts of remainder interests in homes and farmland with a retained life estate can be a powerful technique. As this simple strategy demonstrates, creative and powerful charitable planning is not just for the wealthy. This has been Charitable Gifts of Homes and Farms with Retained Life Estates. Thanks for joining us.